Hello and welcome to FPJ's weekly roundup of important court rulings. I am Urvi Mahajani. Here's a quick look at some of the key legal developments from the Bombay High Court this week. First, an anti-corruption bureau trap that finally came to an end after nearly 3 decades. The Bombay High Court acquitted a former court clerk after almost 29 years after he was caught by ACB trap for allegedly accepting ₹500 bribe. Justice N.J. Damadar set aside the clerk's 2003 conviction, holding that the prosecution failed to prove the most important element in a corruption case, the demand for illegal gratification. The court found major contradictions in the prosecution's evidence, including conflicting versions about when the complainant actually approached the ACB. It also noted that the investigators had not independently verified the alleged demand for laying the trap. The High Court reiterated that merely recovering tainted currency notes is not enough to secure a conviction under the Prevention of Corruption Act. Without proof of demand, the offence cannot be established. The court said it cannot rule out the defence's claim that the complainant had thrust the money into the court clerk's pocket. As a result, the conviction was set aside. Next, an important ruling on land acquisition. The Bombay High Court held that the government cannot allot land to a project-affected person before lawfully acquiring it and compensating the original owner. The court declared that the acquisition of a land parcel in Pune had lapsed because the state failed to prove that it had taken possession or paid compensation. The bench observed that there was no possession receipt or panchnama on the record, and that government had also failed to establish the compensation was ever offered to the landowner. Since the acquisition itself had lapsed, the court quashed the allotment of part of the land to a projected family. At the same time, the judges directed the state government to provide alternative rehabilitation land to the family in accordance with law within 8 weeks. Moving on to ongoing hearing on the Plaster of Paris idols this week. The Maharashtra government told the Bombay High Court that immersion of PoP idols in natural water bodies should be phased out gradually rather than through an immediate ban. Advocate General argued that such a major social change cannot happen overnight and should be achieved through consensus instead of sudden restrictions. The state emphasized that number of large PoP idols immersed in Mumbai natural bodies have reduced significantly over the past year. The court is hearing petitions seeking implementation of the Central Pollution Control Board's guidelines that prohibit immersion of large PoP idols in natural water bodies, along with petitions filed by PoP idol manufacturers challenging those guidelines. The advocate for artisans manufacturing PoP idols suggested that devotees should perform immersion ritual symbolically by touching the idol's feet to the water, after which the civic authorities would transport the idols to designated collection or recycling centers. The court has asked the state to consider the suggestion. The arguments in this matter will continue this week. And finally, a significant judgment on deemed conveyance. The Bombay High Court ruled that the developer cannot indefinitely delay transferring land to a housing society simply to take advantage of additional floor space index available under new development regulations. The case involved a housing society in Mumbai's Ville Parle, where the developer challenged an order granting deemed conveyance to the society. Rejecting the challenge, the court said that once a housing society is formed, the promoter has statutory obligation under the Maharashtra Ownership Flat Act to execute the conveyance within 4 months. Justice Sandeep Marne observed that the developer cannot postpone the transfer merely to earn future profits through additional FSI. Coming down strongly on the developer's conduct, the court remarked that it would not allow its jurisdiction to be used to help a promoter endlessly exploit development potential that legally belongs to the housing society. That's all for this week's roundup from the High Court. For more legal updates, follow our channel.